Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss the topic of preventive detention. Normally, when an offender, even though he is arrested on number of occasions, continues to commit the offense, to prevent his activities, PD Act will be imposed on him. In Prakasham district, in our neighbor Pramod village, PD Act yesterday was imposed on a woman, I should not tell her name, for NDPS Act. So, preventive detention is a colonial legacy. Preventive detention gives arbitrary powers to the government. This is what is stated by Honorable Supreme Court of India. In the case of Pramod and others versus Union of India and others, wherein Honorable two judges bench, Justice Krishna Murari and V. Ram Subramaniam, held that preventive detention order is a colonial legacy and it has great potential of abuse and misuse also. So, these preventive detention powers should be critically analyzed, critically examined, and the PD Act should be used only in rarest of the rare cases. This is the suggestion of the Honorable Supreme Court of India. We know where A.K. Gopalan case 1950 versus State of Tamil Nadu, State of Bhim Singh versus State of Jammu and Kashmir, where people were tried to be detained under preventive custody. Previously, there was a MISA, Maintenance of Internal Security Act. Presently, TADA or terrorist activities. So, the acts have been repealed. Presently, they are not there. But still, preventive detention is there. This is definitely necessary, but should be sparingly used. This is what the Supreme Court said. As elders also we say the same. As retired police officers, we know when to use the PD Act and against whom to use the PD Act and why to use the PD Act. So therefore, a reasoned decision should be given. What is the advantage? Even without committing any offense, the person can be detained for 60 days, continuously 6 months. That is the advantage. You might have known the use of the so-called PD Act in case of the very famous actor Suman Talwar, who suffered a lot. Of course, luckily he was saved and now he is doing his film career. In the early days, I am telling you, maybe about 1986 or so. Now coming to the facts of this case. In November 2021, a report was sent to the Joint Secretary Kofi Posa, Conservation of Foreign Born Exchange case. So, Kofi Posa, Joint Secretary, and a report was sent against this Pramod Singla and others that they are the syndicate members, They are the syndicate members who were arrested basing on the intelligence report, about the syndicate of Chinese, Taiwanese, South Korean and Indian nationals smuggling gold into India. This is a syndicate which is planning to smuggle gold into India. So therefore, the Director of Revenue, the people arrested them, they sent a report to the Kofi Posa. Ultimately, detention orders were given, they were detained for 60 days. Whenever the detention orders were given, a copy of the same should be supplied to the concerned person and hearing should be there. The hearing should be there. Yes, as a routine procedure, the hearing also started. But here, two problems arose. Number one, the accused has to be supplied with a copy of the detention order translated in his own language. Who are they? Chinese, South Korea, Taiwan people, they don't know English. This is the main problem. Chinese, Mandarin, which is the very difficult language in the entire world, I can say. They don't know English. That's the main problem. So the Chinese man was supplied with a copy of the illegible documents. He was not able to understand. Even though it was supplied in Mandarin language, he is not able to understand the same. Second point, this Pramod Singh's father died while in preventive detention. Right? Okay. So he was allowed to go, and in the meantime the period of detention has been completed, as the government has not decided it within 60 days. There was abnormal delay on the part of the government to extend or not to extend. So since the period is over, he was released. Ultimately, he came to the Supreme Court for quashment of the orders against these people, because it is only on the presumption. They were arrested basing on the perseverance that they are likely to commit the so-called conspiracy, or they like to import gold into India. Right? So, anyway, Supreme Court stated that the PD laws, the preventive laws, are a colonial legacy. They should be sparingly used. Already there is inordinate delay on the part of the state. Therefore, the PD order has been dismissed and the people are set aside. So please remember, very good case law. Please read it. Very rarely we get case laws on preventive detention. Okay. So it should be used very sparingly, only in rarest of rare circumstances. If you know this much, it is sufficient. Thank you.